$5,000 paperweight. You spend weeks meeting with a lawyer. You've signed 50 pages of legal jargon. You paid thousands of dollars for a revocable living trust. You feel good about yourself. You think my family is protected, we've skipped probate, and all is right with the world. But here's the scary truth. Statistics show that nearly 60% of trusts are underfunded or they're completely empty. In the industry, we call this the empty trust trap. If your trust is empty, that expensive binder is nothing more than a $5,000 paperweight. So today, I'm going to show you exactly how to fund your trust so that your plan works when your family needs it the most. In Arkansas, there are two types of trusts that are recognized: inter vivos or living trust and testamentary trust. With an inter vivos trust, you must have a competent settlor or trust maker, a trustee, a definite beneficiary, unless it's a charitable or a certain statutory trust. It must contain trust property, and you must have had the intent to create that trust, and everything has to be signed and notarized. Now, testamentary trust is the type of trust that's created through a will, and it only becomes effective upon the death of the person who created the will, or the testator. Now, it's designed to manage and distribute the testator's assets according to their wishes as outlined in their will. Today, I'm going to walk through 5 steps that will help you turn your $5,000 paperweight into your family's security. Your estate plan is only as strong as your funding. With clear titles, proper documentation, and consistent follow-through, your Arkansas trust will operate exactly as you intended it to, exactly when your family needs it the most. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've also worked for a Fortune 100 company, and I've held the positions as Director of the Department of Labor, as well as the Executive Director of the Arkansas Fair Housing Commission. Today, I'm the Managing Attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had many families deal with this very issue, and I hope this video provides you some insight in how I give advice to my clients, which is different for each and every client. So let's jump in. Part 1, what is funding and why does it fail? Think of your trust like a suitcase. You could buy the most expensive, high-tech suitcase in the world, but if you don't actually put any clothes inside of it, you're going to arrive at your destination with nothing. Many people think that once they have signed their trust, their house, their bank accounts, and any other assets automatically move inside. They don't. You still own them in your individual name. So therefore, we need to title the assets in the correct way. 1, it has to be titled John Doe, trustee of the John Doe Living Trust, dated June 4th, 2022, and you have to keep that format uniform throughout. Then you execute a certificate of trust, because many Arkansas institutions want to at least see that that trust exists, what the trustee's powers are, and the relevant dates. And the certificate doesn't disclose the full trust terms. So just keep these documents available. You need to maintain a funding schedule and an evidence file. This helps you create your asset inventory list with account numbers, transfer methods, the date that you completed those transfers, and any supporting documentation. You should also keep deeds, confirmations, assignment interests, beneficiary forms, and other institutional acknowledgments together as well. I would also recommend you update your insurance and address records so you can align your property and casualty policies, your liability limits, and other mailing addresses so your trustee can avoid gaps and lost notices. Coordinate your beneficiary designations to make sure that your paid on death, transfer on death, life insurance, and retirement beneficiary designations are all consistent with your trust distribution scheme, so you can also have good tax planning, which also avoid conflicts. Now, some institutions may have their own unique forms or their own unique requirements, so make sure you check with that institution for their instructions and then submit your certificate of trust. Always follow up to maintain written confirmation to make sure that your retitled and designations have been done correctly. You should revisit this funding when there are major life events such as births, deaths, when you acquire property, when you fund property, when you designate assets to the trust. Also consider the tax implications. Now, for revocable trusts, the settlor's Social Security number is generally used during their lifetime. When they pass away, or if the trust becomes irrevocable, then you obtain an EIN to adjust for reporting. Make sure you consult your tax attorney to get more information on gift tax implications. Part 2, the big three. You must retitle your assets of the big three categories for your family, and you have to do this manually. Real estate. This is the big one. You need to transfer a deed. Your attorney should help you file a quitclaim or warranty deed that changes ownership from John Doe to John Doe, trustee of the John Doe Living Trust. If you don't see that on the new deed recorded at your county, the house is not in your trust. 2, bank accounts. You literally have to go to the bank. You have to show them your certification of trust, and you have to tell them that you want to retitle any checking or savings accounts. They'll give you a new signature card at that particular point. 3, taxable brokerage accounts. E-Trade, Fidelity, Schwab, they don't sell stocks. You just change the name on your account. To learn more about how we assist our clients with these and other types of legal situations, click below and let's get started today. Now, let's talk about part 3, the beneficiary pivots, IRS life insurance. Warning, do not retitle your 401k or IRA into the name of your trust while you're alive. If you do, the IRS will treat this as a full withdrawal and hit you with a massive tax bill. Now, for retirement accounts and life insurance, you can keep them in your name, but at that point, you just give a new beneficiary designation. Now, in 2026, with the new $15 million tax limits, many people name their spouse first and then their trust as the secondary beneficiary. This ensures that the money pours into your trust protections only when you need it. Part 4, the pour over wheel safety net. Now, what if you forget something? What if you open a new bank account after 3 years from forming your trust and forget to put it in the trust? This is why your lawyer will give you a pour over will. It's a special kind of will that says, anything that I forget to put in my trust, I want to pour it into it at the time of my death. Now, the pour over will is a great backup, but here's the kicker. It still requires probate. It's a safety net, but it's a slow and expensive one. The goal here is to never have to use it. And part 5, the annual audit. The empty trust trap happens because life moves fast. You buy a new car, you open a high yield savings account, and you forget to put assets into the trust. Proper funding ensures A, your trustee has immediate authority to manage your assets upon your incapacity or death. B, probate is minimized or avoided for funded assets, which saves time and money. C, your distribution plan is executed and consistently and effortlessly and efficiently done. And D, creditor protection, tax planning, and special provisions for beneficiaries function as intended. I've created a trust audit checklist to help you get started. Click the link below, provide your contact information, and we will send you via email a free trust audit checklist. The stakes underscore the need for professional guidance and coordinated planning with an experienced attorney. I encourage each of you to evaluate your particular situation early and discuss your unique needs with a qualified professional to secure the best possible outcome for yourself and your family. If you found this video helpful, please hit the like button below, subscribe to our channel to learn more about valuable information how we help our clients here at Big Rock Legacy Law Group protect their legacy and advocate for their rights.